Hi everyone, in this week's MMD we are discussing yet another change for 2024. This to come into effect in October of this year, and it's a mandatory duty to prevent sexual harassment in the workplace. So this is implemented by the Worker Protection Amendment of Equality Act 2023, and essentially it does amend the Equality Act in relation to harassment provisions. So it firstly introduces a duty on the employer to take reasonable steps to prevent sexual harassment of the employee. It also gives tribunals the power to uplift sexual harassment compensation by up to 25% where an employer is found to have breached the duty to prevent sexual harassment. Prior to the Equality Act, we did have the notion of third-party harassment, so employers being potentially liable for the acts of customers on their workplace, for example. That's not been taken forward and does not form part of the new introduction of the rules. So we have a new section 40A in the Equality Act. This includes the mandatory duty, and the employer will at that point be required to take reasonable steps to prevent sexual harassment. Now, the Equality and Human Rights Commission also has the ability to enforce the new duty, and tribunals can uplift compensation where it finds there's been a breach. If the EHRC does get involved, they have powers of investigations, can issue notices of unlawful acts, can implement action plans with the employer and hopefully come up with agreements. A failure to comply with an EHRC order can result in a potentially unlimited fine being applied. So it is important not only in the context of employment tribunal claims, but also standalone action that the Commission might want to take. There's also a statutory code of practice on sexual harassment. On the 15th of January 2020, the EHRC published technical guidance. It said it would be updating that, and instead of issuing a brand new code of practice to go alongside that legislation, the existing guidance will simply be updated. So it's an important piece of legislation coming into force. It does add another layer of protection for employees, largely in the event that a successful tribunal claim is brought. So the positive duty largely kicks in at the point of which compensation is applied. But if you do need any further guidance on how to comply with that duty and take reasonable steps moving forward, do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.